Welcome to The Explainer. Today, we're unpacking a dense 15-page Supreme Court labor decision to uncover a really fascinating David versus Goliath legal battle. We're looking at a case that forces us to question the fine print of employment contracts and, honestly, what actually happens when human health collides directly with corporate liability. So I want you to imagine an absolute nightmare scenario. Imagine suffering a massive heart attack on the job, being rushed to a hospital in a foreign country for emergency coronary bypass surgery, being declared permanently unfit to ever work in your profession again, and then, after all of that, being handed a check for $20,900 to just sign away all your rights. For a lifetime of lost wages, that number feels incredibly small, doesn't it? Well, that is the exact scenario we're looking at today through the case of Paulo Devontes. He was a veteran seafarer who'd worked for his employers for 20 years with a completely unblemished health record. When tragedy struck, he refused to just take that initial check and walk away. Instead, he took his corporate employers all the way to the Supreme Court of the Philippines. And the legal precedents set here, they matter to absolutely anyone who signs an employment contract. Section 1. A heart attack at sea. Let's dive into exactly how this terrifying emergency unfolded aboard the vessel BSL Elsa. On May 13, 2017, Devontes passed his medical exams and was hired as an able seaman. But fast forward to June 24th, the crew was ordered to undertake an emergency drill under the sweltering heat of the sun. The drill took a massive toll on him. Still feeling dazed, he reported for his midnight shift anyway. By 3 a.m., his heart was beating abnormally fast and he literally felt like he was suffocating. By 9 a.m., he was evacuated to a shoreside clinic in Venezuela, which quickly escalated to emergency coronary bypass graft surgery. It was, simply put, a catastrophic medical event. Moving on to Section 2, the $20,900 quitclaim. So, after surviving the surgery, Devontes was flown back to the Philippines, diagnosed with coronary artery disease, and declared permanently unfit to work by multiple doctors. His employer, CF Sharp, offered him a settlement of $20,900, but in exchange, they had him sign a quitclaim. Now, a quitclaim is basically a legal waiver where a worker gives up their right to pursue any further claims against an employer. The thing is, the Supreme Court has repeatedly noted that quitclaims are generally frowned upon in labor law because they're often contrary to public policy, unless, of course, the payout is completely fair and reasonable. And this right here is where the dispute really begins. You see, the company-designated physician gave Devontes a disability grading of grade 7, which is meant for a moderate residual disorder. That specific grade triggered the $20,000 payout. But because Devontes was permanently unfit to work, he soon realized he was legally entitled to $60,000 for total and permanent disability under standard overseas employment contracts. Basically, he was paid for a moderate injury, but he had suffered a career-ending one. Which brings us to Section 3, the legal tug-of-war. Realizing this massive financial discrepancy, Devontes filed a new complaint, kicking off a wild judicial roller coaster. First, the labor arbiter sided with him in validating that quitclaim and ordering a massive payout of nearly $78,000 based on a union collective bargaining agreement. Next, the NLRC modified it slightly. They kept it in favor of Devontes but lowered it to the standard $60,000 because a heart attack didn't technically meet the union's strict definition of an accident. But then, in a stunning reversal, the Court of Appeals threw the whole thing out. They ruled in favor of the company, dismissed the case entirely, and basically said Devontes was entitled to $0 additional dollars. So what happened? Let's look at Section 4, the accusation of concealment. To understand that sudden reversal by the Court of Appeals, we really have to look at the shipping company's main defense strategy. They dug up that years earlier, back in 2010, Devontes had actually been diagnosed with hypertension by a private doctor and occasionally took a medication called clonidine. However, on his pre-employment medical examination, his PMA, he checked the no box when asked about high blood pressure. The company claimed he knowingly hid this diagnosis to secure his job, which, under the rules, completely disqualifies a worker from receiving benefits. Now, the Court of Appeals found themselves in a bit of a tricky spot here. They openly acknowledged that the company actually fumbled their own legal deadlines by failing to issue a final medical assessment within the mandatory 120 or 240-day window after his repatriation. And by law, that procedural failure automatically makes the disability total and permanent by default. But the Court of Appeals decided that Devontes' alleged deception, hiding that 2010 diagnosis, canceled out his right to any money, essentially trumping the company's own procedural failures. Section 5. The Supreme Court's logic. This high-stakes stalemate finally brought the case all the way up to the Supreme Court, who applied a deeply pragmatic, reasonable person test to the medical exam itself. Because Devontis was 50 years old at the time of the exam, he wasn't just given a basic checkup. He had to pass the PMEC physical. This mandatory battery of tests includes an ECG, fasting blood sugar, total cholesterol, and blood uric acid. It is an incredibly extensive cardiovascular and blood workup. And the justices applied some pretty unassailable logic here. They reasoned that if Devontis truly had a severe pre-existing hypertension condition that he was actively trying to hide, well, this extensive battery of mandatory clinical tests would have easily caught it. Blood chemistry and an electrocardiogram simply don't lie, regardless of a checked box on a medical history form. So a doctor declaring him fit for sea duty after all those tests meant one of two things. Either the medical examiner found absolutely no hypertension present at the time, or the examiner completely failed to do their job properly. Section 6. The final verdict. Siding decisively with the worker, the Supreme Court completely invalidated that initial lowball quitclaim. They recognized that the compensation was just grossly disproportionate to a career-ending injury. Step 2, they ordered the company to pay the full $60,000 for total and permanent disability, naturally deducting the $20,000 he had already received. And Step 3, to make him fully whole, they added a 10% attorney's fee penalty and a 6% annual interest rate until it was fully paid. I absolutely have to highlight this quote from the decision because it just beautifully summarizes the reality of the working class. The justices noted that seafarers are laypersons. They aren't doctors. Honest mistakes on a complex medical form, especially about a condition from 7 years prior that wasn't even actively presenting symptoms during a rigorous physical, do not equal intentional deception. An honest mistake does not erase a company's financial responsibility when a worker's health is completely destroyed while carrying out their grueling duties. Ultimately, this Supreme Court decision sets a really firm precedent regarding the enforceability of quitclaims and the burden of proof in medical exams. It leaves us with this final thought to ponder on corporate accountability. When a worker gives 20 years of their life to a company, only to suffer a career-ending emergency on the job, how should the law balance the strict terms of a contract against the harsh realities of human health and survival? Thanks so much for joining me on this explainer, and remember to keep asking the tough questions.